My Lords, just before Mr. Lowe begins, he's kindly allowed me to just update the panel as to the position on Professor Bourne's extract in particular.
Thank you.
What we suggest, subject obviously to what the panel considers is best, is that we provide the panel during the course of this afternoon with the relevant extract from Professor Bourne's book. And having had a quick read of it over the short adjournment, we think that, from our perspective anyway, is likely to be sufficient, and we can address that tomorrow. If the panel would be kind enough to just read the extracts overnight, we think that would be the quickest way of dealing with it. Obviously,
some of us, I think, have
if it's not
already, but
oh, I see.
Yes, that would be very helpful. And at least we can identify.
Absolutely.
Identify the ones you think we should read.
Yes, absolutely.
There are any others?
So we shall do that, and then and address the issues tomorrow. And if there's anything else that the panel would like, obviously we would happily deal with that. We think that's the best way forward.
Thank you very much indeed. Mr. Lowe, before you start on your submissions, are you content with that course?
Well, I haven't seen it. It may be that there's a decision from Hamburg or somewhere that might look useful, which may mean that we ought to find it and give it to you. I don't know until I've read the extracts.
At the moment, then, you're reserving your position?
Yes, if I may.
I understand. Thank you very much.
I also suggested if your lordships, on reading it, think that there are decisions which you might like to see, we will find them for you.
Yes. Thank you.
Can I just start by trying to dispose quickly of a couple of jury points? A learned friend said that his clients hadn't received a single cent from the transaction. Well, MP funds were not the sellers, so technically as sellers they wouldn't have received anything. They had, however, the entire economic interest in the sellers by the time of the agreement, and they had preference shares in the seller, and they'd also made loans to the target. And you'll find the arbitration award deals with that at pages 2084 and 2085 of the bundle. I don't ask you to turn it up now. It seems to be the case that they were the only persons with an economic interest, and I showed you the passage, or my learned friend showed you the passage. The tribunal said the price had been paid. You're asked to take comfort from the decision of the US court. As far as we understood it below, the absence of an arbitration agreement in the US is a matter of public policy. And so for whatever reason, it was never raised as an estoppel. We never argued about it. And I suggest you can't get any comfort from it. Issue estoppel, we say, is an answer to 90% of the grounds relied on. The appellants argued in Brazil that they were not bound by an arbitration agreement, and they lost that in the lower court and the Court of Appeal. They also argued that the award went beyond the sums claimed, the petitum, which is the claim made in the terms of reference. They also argued, incidentally, that it was outside the scope of the arbitration clause because the arbitration clause only covered the non-compete obligation they assumed in the addendum. So my learned friend was not quite right when he told you his argument was confined, or his client's argument was confined to the terms of reference, at least not in Brazil. And in fact, I think that was also the position in front of the judge. And thirdly, the funds argued that they'd not been treated fairly, that they'd been surprised by the tribunal, and that there hadn't been due process. And although that's not a complete answer to a question of Cayman English law, all the courts dismissed that complaint. So in that respect, we say you're 90% there with an issue estoppel, not quite. It's a relevant fact when you decide the question of Cayman law.
Well, issue estoppels don't work on a percentage basis.
No,
they're an all or nothing.
Yes, but you have a question whether there's natural justice according to Cayman law. It's relevant to that question that there has been due process in Brazil, and that's been decided.
You mean that they've decided that there was due process in the arbitration?
That they decided, and why they decided there was due process, so that they were treated in the same way as any other Brazilian litigant. And what that means, I'll show you that probably tomorrow, because it's much broader than simply Jura Novet Curia. It's broader than the Court of Appeal suggested it was. So I was going to start with issue estoppel, if I might. And first of all, just very quickly look at the principles on identifying the issue, comparing Brazil and Cayman for the purposes of the arguments made on the appeal. And then I would like to address the complaint made about the Court of Appeal's interpretation of Brazilian law, arrogating to itself its expertise, as it were. And then, if I have time, I wanted to show you how the Brazilian court dealt with the issues of substantive law, because although my learned friend says he doesn't challenge those, he clearly does on the terms of reference, because the Brazilian courts decided that the claim did not go beyond the pleading, and he's now arguing that it does. He can argue that again when we say that's already been decided. So at least two of the issues I've got to cover that were dealt with in Brazil. So as far as identifying the issues is concerned, I accept, of course, what Lord Justice Diplock said in Tode, but in the Senna, and you see this at 5930 of the bundle, at letter B, he doesn't refer to identity of conditions, identical conditions, as he does in Tode. He refers to the issues being the same, which you can, is a question of substance, not just form.
Sorry, which page reference was that?
4930 at letter B.
Thank you.
He deals, you may remember he has a very pithy summary of the principles that apply to issue estoppel, and that's one of them. It's the last one in that paragraph. The second point I'd like to make is that issues are decided provided that the parties have raised them as legitimate questions and the court has disposed of them. It doesn't concern another court that the reasoning is terse, that the reasoning is not what you would have. You're not examining the logic of the Brazilian courts, you're examining whether they've made decisions, save perhaps on the question of fairness. I accept, of course, the statements of caution in Carl Zeiss and the Good Challenger, but you're dealing here with arbitration challenges inspired by an international convention. Santos agreed they were inspired by the New York Convention, the challenges in Brazil, even though they were also to domestic arbitrations. And when you look at them, you'll recognize them, as did Sir Bernard Ricks. They're familiar headings of challenges for arbitration. So it's not like in the Good Challenger looking at a Romanian statute, or in Carl Zeiss looking at the German pre-unification law of companies. So the degree of caution, you have a bit more assurance when you're looking at an arbitration challenge that you're dealing with something that you've already seen if it looks like that. And it is on that basis, when you look at the arbitration law, can we have a look at 3775, which is this is the Article 32 of the Brazilian arbitration law. And it looks rather odd because if you look after, Article 32 at the bottom of the page, it was agreed that that is essentially as the arbitration agreement is it valid. If you go over the page to 3776, the numbering's all awry. We corrected that in Mr. Gomes Santos's cross-examination. But it should really be, because it's the formatting of the translation, it should really be 2, 3, Roman 4, Roman 5, Roman 6. And if you look at these grounds, the language might be a little bit more brief than in the convention. Exceeded the limit of the arbitration agreement, doesn't resolve the entire dispute submitted to arbitration, extortion, so on. So some of these certainly ground what would be 4 and 5 are similar, and then Article 21, paragraph 2, which is referred to in 7, if you look at page 3773, Article 21, paragraph 2, principles of due process of law, equal treatment, impartiality, freedom of decision shall always be respected. And that's the due process provision. And when this was put to Gomes Santos, he said these are really the same grounds as the New York Convention. He called them very similar, and the same issues arise. And the point is that the same issues can arise under those provisions. And the reference to Santos agreeing that is in the bundle at 429. 429, he says between 14. Sorry, my lord.
What page, Mr. Lowe?
429, my lord.
429. Thank you.
Between 5 and
on which of the smaller pages?
61, transcript page 61.
Yep.
Sorry, 5 and 12.
Yep.
Mine's 5 and 12.
Very similar to the New York Convention. Yep.
Yeah. And he says, for example, when dealing with due process, on page 434, the bottom of 82 going to line 5 of 83, it's essentially Article 5 of the New York Convention. You're making just that complaint you could be making about the surprise due process we were looking at, you could make under the New York Convention. We'll come to the precisely what due process is in Brazil in due course. I'm not going to try and do that now. Because he had no difficulty accepting that the grounds in Brazil for challenging an award were really not very different from those in the New York Convention. Very similar, he called them. And there's no issue before you that the grounds are actually different. I think that was a question my Lord Kitchen put to my learned friend, that you're not arguing here that the grounds are substantively different. You're arguing about the procedure, the de novo review point.
Well, Mr. Flynn made it clear that's his only...
Yes. So I don't know who asked the question. I'm afraid.
I asked the question, but don't worry.
I'm so sorry. Not the first time we've got attribution wrong, but... So the case appears to be, as I think your lordships got from the learned friend, and the difference in the issues appears to revolve around whether in England or Cayman you have to have some form of what he calls a de novo hearing, and whether in Brazil you do something what he describes as merely a review. And my first problem is really with the nomenclature. A de novo hearing, a Latin tag, is obviously has a lot of meaning for us. But if you have an appellate court which decides cases by way of rehearing, it actually does it by way of review. What do we mean by a de novo hearing? There's no evidence at all that that language is used in Brazil. My learned friend then says, well, in Brazil all you have is a review, and you may remember in Dala that counsel for Dala, I think Ms. Heilbronn, argued that there should be this light touch review, and it was dealt with in the House of Lords, I think it still was, may have been the Supreme Court, at 3543, paragraph 21. But I'd like to show you what Lord Justice Morbick said at page 3509. He describes it as unhelpful because it doesn't really mean anything.
'21.
3509.
Yep, paragraph.
I'm so sorry.
This is 21 again.
Thank you. And it is in the Supreme Court as well, both times, paragraph 21. So it was surprising to us, given the criticisms made of that sort of language, that Mr. Gomes Santos used it in his affidavit. And you remember being shown pages 293 to 4, those two paragraphs. Might just be worth resurrecting those, just so you can see how odd this is. Because it's nowhere used in the Brazilian statutes, in the Brazilian textbooks, in the Brazilian judgments. It just appears. It looks like an Anglicism that's wandered into his evidence.
It's discussed in Bourne, isn't it?
Maybe, yes. I don't know if it is, but...
Well, we were referred to the passage at 2850.
Yeah, but it's wandered into his affidavit without explanation. And the meaning of those words isn't explained by reference to Brazilian procedure. The judge adopted the same nomenclature at pages 58 to 59, paragraphs 126 and 127. Again, without explanation of how that relates to Brazil. So although I might refer to it as the de novo review debate, I would like to not use this nomenclature and use what I understood to have been the nomenclature introduced by Dala, ordinary judicial determination, which is at 3546, paragraph 28, and which is quoted in my Lord's more recent decision, which I'm going to call KFL for want of a better name, at 4646 to 7. KFL, which I wasn't going to take your lordships to, because it's such a recent decision of two of your...
That's Kebabji, is it?
Yes. And since two of your lordships were giving judgment, I just want to briefly summarize what I suggest it shows. It establishes that for an English court to decide how to undertake an ordinary judicial determination according to its own civil procedure rules, etc. And you see that from paragraphs 80 and 83 at 6447 to 8. If that's correct, it tends to support a submission that the mode of proof of the grounds doesn't by itself at all mean a change in the legal issue that the court's considering.
No.
Secondly, it's worth pointing out what...
that was in the context of summary.
Yes, summary, exactly. The second point about the form of procedure here is there's no reason in England or Cayman why, in deciding the legal issue, you can't have regard to the tribunal's own reasoning on its own jurisdiction findings, for example. In KFL, that point is made at paragraph 79, letters D to E. In Dala, it was made by Lord Justice Morbick at 3509, letter C to D. And Lord Mance made it on page 3547 at paragraph 31. Our case incorrectly refers to Lord Collins making that point. I don't think he did. But it's important because it isn't a criticism per se to say that a court reviewed the tribunal's decision. It's whether that is all it had to do, whether it's essentially a sort of judicial review on a Wednesday basis. As far as estoppel is concerned, and you're, of course, at that stage, you're looking at how an English court goes about dealing with a challenge. But estoppel, there's some additional points to make. It shouldn't matter to an English court or Cayman court how the facts were decided, provided they were decided. The Senar says a decision has to be on the merits, and my lord, when he was Mr. Justice Legate, decided in UKOS, which is the reference is 5076, that you don't need a full contestation. And
It might have been me, actually.
Yeah, I don't think I decided
I'm
that.
so sorry. My second error on the church. So sorry. I'm so sorry. Well, your lordship was followed on that point by Mr. Justice Butcher in one of the Russian bank cases at 4605. So long as the foreign court actually decides an issue, it doesn't matter, as I said, if it does so on the barest of reasoning. An example of the court not deciding the very legal substantive issue is perhaps if there is no more than a judicial review, in other words, a judicial review in the traditional English sense, where one looks at whether or not the court has behaved reasonably, whether it has behaved in a Wednesbury sense reasonably. But there's no evidence at all that that is what the Brazilian courts did. Quite the contrary, and it's never argued in that way when you look at the arguments.
Well, you didn't put any evidence to explain what they did.
Well, I'll come to that. That's a bit rich from a learned friend, because what happened was Mr. Santos's third affidavit was the last affidavit before close of evidence. We had an oral trial with oral testimony. It was served, I think, on the 18th of May.
What was it, your application to enforce, was it?
No, it was theirs to set aside.
Oh, yeah, I see.
So they had the last word. The skeleton,
that was when it first came in, was it?
two little paragraphs at the end. 10 days later, we get their skeleton doesn't mention the point. We mention estoppel. It comes in their reply skeleton, and the judge then has the hearing a month after the skeleton. So we didn't have an opportunity to deal with this, but we dealt with it in cross-examination. And
So were you relying on issue estoppel from the start, or?
well, the issue there were no pleadings, So the problem is you have affidavits putting in. We had, I think, a lot more evidence than I've got now. I seem to remember there were some 5 lever arch files with 1,000 pages each at the hearing. But it's a bit rich, really, from a learned friend to say we didn't put any evidence in, because it's such an obscure point anyway that there was just a review rather than a de novo hearing. We put in all the judgments that showed what had been decided, and the only point of doing that was to rely on issue estoppel. But as it happened, Mr. Santos was quite helpful in his oral testimony, and we had enough from the statutory material to make the points we needed to, in response to my learned friend's point about de novo and so on. So that's all I really want to say about the English principles or the Cayman principles. And then I was going to look at what happened in Brazil, first by looking at the legal process in Brazil for challenging an arbitration award, and then to see what actually happened in this particular case. You were shown Santos's written evidence. I've shown it to you again. So what happened was when he gave oral evidence, and when you looked at the statutory material, it appeared to be entirely at odds with his written evidence. First of all, none of none of the language that he used is to be found, as I said, in the statute anywhere. None of it is to be found in the judgments, and none of it appears anywhere apart from Mr. Santos's evidence in relation to Brazil. I mean, it might be in Mr. Bourne's book, but it doesn't seem to be used in Brazil at all, that language, that nomenclature. The Brazilian procedure, we looked at the Arbitration Act. I'm going to have to, afraid I'm going to have to ask you to look at it again. It's 3775. It's a different section. Section 33, sorry, it's page 3776, sets out in the Arbitration Act, refers you to the Civil Procedure Code. A request for, this is paragraph 1, a request for the declaration of nullity will comply with the rules of cognizance procedure set up in the law, which is the Code of Civil Procedure. It must be filed within 90 days. And the request can also be made if there's, it will set the arbitral award aside. Declaration of nullity can also be raised by means of a debtor's defense. That's paragraph 3. And when Mr. Santos was cross-examined about this, and we start at page 429, at page 64 of the transcript. This is, I took him quite slowly through what that meant in terms of procedure. He accepted at the bottom of 64 the annulment action was like any other action, over to 6512 on page 430. He then accepted on page 65 at line 13 that unlike company litigation and the rest of what we know as special litigation, there was no special procedure for arbitration challenges. No special form of action. He said at 6612 to 6618 that the procedure to determine annulment action was very much like our own, any other normal procedure. If you look at how he describes, if you go from 6612 to 6819, I put to him the sorts of things that happen here.
That all seems to be about the procedure, though. It's
but
whether you have summary judgment or you that kind of thing. We're looking at in Kebabji.
Yeah, we'll get to what the Court of Appeal said actually happened, but on the face of it, you see an annulment action being set up like any other action, there being no requirement anywhere for a special procedure to be followed for annulment actions. There's no case law that says it's a special procedure. Mr. Santos may have said what he said, but there's absolutely no other support for it. On the face of it, all you see is a normal action going to the judge, and he deals with it like any other normal action. He has Article 32 sets out facts he has to find, some of which the tribunal could never find. And so obviously the judge is making findings of fact under Article 32. And Sir Bernard Rix's point is, well, if Article 32 sets out facts like due process and terms of reference and so on, which the tribunal is never going to deal with, it stands to reason that the whole thing is a sort of a menu of facts which the judge can decide and has to decide. And there's absolutely no support for Mr. Santos's comment that there is some form of limited review, or review different than in any other Brazilian case.
Well, I thought Mr. Cremona...
No, he doesn't say that. That's a different point. That's about, with respect, I think that's about whether Jura Nova Cura applies in an arbitration. Carmona doesn't say anything about this. And
well, he does in a book that we refer to.
2859, I think it is.
2859?
That's what we referred to.
Oh, sorry, this is the recent article on the additional material that was given to. Yes, I think.
Well, what was the date of this article?
I think it's 2012, I think.
20.
Can I come to the article, because I have some...
Okay, whenever.
I have some sort of fairly trenchant things to try and say about it anyway. But I'll get to that. He agreed that the pleading in our case, and this is you can see this at page 431, 72, 15 to 19. I showed him the pleading. This is the pleading in the annulment action. This is the MP funds pleading, and it goes over to 73, about 18. He's at the bottom of 73. He says there's nothing unusual. I said there's nothing unusual about it, and he said about the way it looks in its presentation. He said no. It's also relevant that the parties can, on an annulment action, having done the pleading, they can present further evidence, which the judge then has to consider, which wouldn't be the case if it was a review. And he deals with that at 433, page 7722. One of the paragraphs in the statement of claim, or whatever they serve, it's paragraph 214. I can show it to you. The reference is at 2294. It's in Portuguese, but it's very obvious what it means. He agreed was a request to produce such evidence as the court might want, and there's nothing unusual about that. There's no reason why in an annulment action you can't produce further evidence. And I think he also says the Court of Appeal is able to do this. That's at page 437, transcript page 94, line 18 to 24. And that cannot be the case if the court is limited to carrying out a review. Santos, in his evidence, failed to mention Article 33 at all in his affidavit. Nowhere did he describe the rules of civil procedure. He failed to make any comparison between ordinary procedure and the sort of determination he said might just be a review. And he didn't explain how, following these ordinary rules of civil procedure, you would end up with anything other than an ordinary judicial determination, in the sense of one that is like any other case. And then, of course, against his view is the fact, as I mentioned before, that you can't get away from seeing that a number of the issues in Article 32 simply have to be decided as fact. So you would have a completely different process for Article 32(1) to the remaining subparagraphs, which would be very odd. And my learned friend has shown you the passage where I cross-examined him on the basis the judge makes a decision in an annulment action on due process, the same way as he does any other. So that merely reinforces that point. Can I come to the Sester article, which is at 2859. Now, in the case, it almost reads, the first time I read it, it looked to me like he was a professor at Oxford, but he's not. He's a professor at St. Gallen, which, of course, is a very good university, but it wasn't really an English commentary in that way, so just so you know. Sorry, I'm just trying to make sure I got the...
I think it's not his opinion that's of any interest. It's what he says is written in the leading book on Brazilian arbitration law.
Well, this is produced to us only on this appeal. The text contains no discussion of Articles 32 or 33. It contains no discussion of this case. I think it's actually dated 2020, the article. Professor Carmona was not cross-examined about what happened at the conference he went to, which is what's being reported. Paragraph 2.156 expresses...
Well, what's said to be reported is what he's written in his book.
Yeah, well, what it does is what is in his book seems to be an opinion about what the law ought to be. Should be limited, a review should be limited. There's no authority given.
Well, there's various decisions of the STJ, which we understand to be the Supreme Tribunal of Justice.
The 2013-2016 decisions are not mentioned by Santos, haven't been produced to us or to this court, nor were they put to our expert, because none of this was. I mean, it's very unsatisfactory to produce an article like this on Brazilian law to tell you what Brazilian law is when we've had absolutely no opportunity to deal with it. And it wasn't put, none of these things were put. There's a case of 2018 referred to, but that seems to be about the defects in an arbitration clause. And if you look further, it seems the defect was forgery. And it's not clear what is meant by the STJ applying the competence principle. It may mean that the court allows the tribunal to decide its own jurisdiction, which is odd. And we know that doesn't happen because of Article 32. Article 8.
That's talking about an executor proceedings. I assume that's enforcement proceedings, is it?
Yeah. And it's not clear whether you... Yes, that might be...
So that's enforcing probably a foreign award, like we're concerned with here.
Or maybe one from Sao Paulo to Rio, who knows? But we don't have any of the backup information, and it's not really admissible evidence to slip it into the authorities bundle in order to demonstrate what Brazilian law is when we haven't had any of the underlying documents. I mean, that's as trenchant as I can put it, but... So
yeah, well, I agree. It's normally a fair process to know what the case against you is.
Yeah. So I was then going to try and show you what happened in the action here. The action to annul, so you can see it, is at 2222.
2, 3,
4 twos. And goes on for over 70 pages. We know it was an action under Article 32. It's quoted, Article 32 is quoted at page 2333. I think it was. Maybe not. It is quoted here somewhere, but...
yes, it is on that page.
Thank you. The relief is set out on page 2294. Santos agreed that this is where you find what's effectively known as the petitum, which is relevant.
Is that the prayer?
Yeah, essentially the prayer. The judge, as you'll see in due course, a judge is not allowed to stray beyond the facts the parties have pleaded, causa petenda, I think it is, and he's not allowed to stray beyond the petitum. And when you look at the terms of reference, the petitum is really what's at the end, the claim, the prayer.
Is there a translation of this?
There's an explanation in the evidence, which I'll come to when I get to it.
What page was that on? Sorry, the
claim is on 2294.
2294.
And Santos agreed that this was a pleading of an ordinary action. I've shown you that passage. The evidence that was allowed, if you go to 2294, paragraph 214, well, we can produce any other kind of proof. So at this particular, not just generally, but at this particular, in this particular proceeding, the judge was offered evidence, and he could have received it, and the Court of Appeal could have received it. You'll see that in a moment. We know that he had 14 volumes of material. If you go to page 2398, we're looking in the Court of Appeal decision, the penultimate paragraph. The complaint was, incidentally, that the judge shouldn't have decided the annulment action summarily. And so the Court of Appeal, if you've had a chance to read it, I think I understood from at least one of the panel that you had, you'll see that on pages 2398 to 2401, they're dealing with the argument about whether or not the judge had power to give summary judgment, just as in KFL. And that really gives you the answer to the review point, because if it's open to the applicant for the annulment to say, well, we wanted a full-blown action, and you shouldn't have done it by summary process, and the judge says, well, I don't agree because I've got all the papers, he's obviously not saying, well, I don't have to because it's a review. He's saying, I just got all the relevant evidence. And if you look at, I think the Court of Appeal looked at how the judge went about this, and if you go to page 2400, they're citing from a text. You can see it starts at 2399. Issue, to be honest, doesn't require the additional evidence to be produced. It's satisfied by producing documentary evidence, since one finds cases related to matters of fact and law. Conditions exist, so on. And if you go over the page, Article 330 imposes the duty on the judge directly taking cognizance and application, handing down a judgment if the conditions exist that make summary judgment the case appropriate. Judge didn't arbitrarily dispense with the need to present evidence, since there was the possibility of summary judgment. If anything shows that here in this case, the process was not one of Wednesbury review, it's that passage. And the judge, as the Court of Appeal noted, had 14 volumes of evidence.
Well, actually, this issue turned on the meaning of one piece of paper, didn't it?
Well, no, I mean, when you look at what the Court of Appeal did, it doesn't. It turns on rather more than that, which is why when we were in front of the judge, I said we didn't have the material to go through those nuances. But they clearly looked. I mean, your Lordship may remember in Dala, there's a discussion by Lord Collins about how different jurisdictions deal with non-parties to arbitration agreements in different places. You know, that's all contractual. And the Court of Appeal deals with it in a way which I don't know the legal concepts. They weren't in evidence. And we had very bog standard evidence about contracts interpretation. That really didn't get me there. So I had to rely on an issue estoppel, because the material was just not good enough for me to do anything else. And also, I'm not sure we would have had the time, frankly, in what was given to us. And in the States, when they'd argued it, it was on that bog standard contract evidence. So that's why I argued estoppel. I just didn't have the material, as I told the judge.
Or was there some other agreement relied on apart from the supplemental clause that was agreed? Well, it was a question of what that meant.
Well, it meant, yes, I mean, why don't we have a look at what it said? Because, I mean, I haven't got to agreement because I was going to deal with that separately after dealing with the de novo and review aspect of it. But we can just turn on and we don't have to go back to it. They deal with the competence discussion, if you remember. And they, for example, on page 2405, refer to paragraph 8 of Article 8 of the arbitration law, which effectively enshrines the competence article point. And then at 2407, we find within the limits of its competence, one finds that as duly decided in the judgment under appeal, the arbitration proceeding was divided into 2 phases. In terms of the possibility or not of the appellants being subject to the arbitration clause, the argument made is based on the theory that the contract, which in clause 14 calls for arbitration to be instituted, couldn't affect its effects to these appellants because, according to their claim, they had not been parties to that arrangement. And then they recite from the judgment about corporate structure, relationship, however, the 5 lines up, relationship. Initially, it must be emphasized the relationship of the plaintiffs with the sellers' companies is perfectly described in detail in the arbitral decision, showing unequivocally the close relationship of the plaintiffs to the companies participating in the transaction, following the transactional format made for the purpose of compliance with the aviation code. It's even noted the plaintiffs in their own complaint unequivocally confirmed their participation in the creation of a reference contract, stating that they even rejected the request to include them expressly. Confirms the argument stated.
Seems rather back to front to rely on the point that they insisted on not being a party to the.
But it might to us.
Making them a party, but
it might to us. But you know, they have this concept which he comes on to on page 2411, which is they call venire contra factum proprium, which means that you can't do something and then do something inconsistent. I don't know. For us, that wouldn't be, but for them, it is.
Hot and cold.
I mean, if you read all this, and then I'm going to show you what the tribunal itself said on its competence finding.
409, they seem to rely on the fact, as the arbitrators did as well, that the non-compete letter was amending the agreement.
Yeah.
They use the word amending. Elsewhere, we've seen supplementing.
Yes.
Translation?
I think that might be translation error, maybe, because in the actual document it's supplementing, as your lordship points out. And it goes on, but the point is, they do have some analysis contractual, which is from an appellate court. One can't just ignore the fact that they go through this, even though to us the reasoning might make no sense at all. They clearly decide that there's an agreement at the end of that. And the tribunal itself actually reasoned the matter out a bit more fully, if I can find the... Forgive me a second. I think it might be page 319, 1119 is the partial award. And at page 1135, they deal with the arbitral tribunal's review of the facts and allegations. 1136, defendant 4 is a signatory. 1137, they deal with the addendum. And the point my Lord Hamblin was making in supplementation, you can see it 1137, supplementary 2, which is all, in all of the adjectivas, they're called addendums, addenda. 1138, they attach some significance to that wording at paragraph 50.
It's paragraph 50, isn't it?
Yeah. And then, you know...
I mean, I read that as being the crux of their reasoning, really.
Yeah. And they have the objective limits of the arbitration agreement is derived from or related to 1140. They deal with that at the bottom.
The basis of the reasoning appears to be that because the addendum says it incorporates all the terms and conditions of the main contract, that bound them to all the terms and conditions of the main contract, including the arbitration clause. And that seems to be the
yeah.
And it may be very odd to us, but I mean that's the reasoning.
Very odd to us, which is why I couldn't justify
both the tribunal and upheld by the Brazilian courts.
I mean, I couldn't go through that reasoning in front of the judge and say, look, that's Brazilian law, because it just looks very odd to all of us. But that's what the court held. That's how the tribunal dealt with it. The judge and the Court of Appeal were perfectly entitled to have regard to that reasoning, because it's, after all, a construction point. There's no real other evidence other than they had available. And you know, the tribunal is probably as persuasive, if not more persuasive, than the Court of Appeal on this point. And the court then, as you know, the Court of Appeal dismisses the challenge based on the absence of an agreement. It might be worth just showing you how all the issues that really were raised, at least at the first instance, were all raised in the court challenges. They're all the same issues. I mean, you've looked at the. Just maybe this is quite an interesting. Well, at page 2242. 2242. This is about not having any notice. Now you'll hear maybe tomorrow, if I don't get to it tomorrow, before then, that one of the constraints on Jura Novit Curia seems to be that in a lot of cases, it seems to be in Brazil, that's Mr. Gonçalves' evidence, you can't just surprise someone. So there's a sort of if there are unforeseeable arguments which would surprise you, then that might be a legitimate complaint. And here you see that is exactly what the MP funds complain about under the heading suppressor.
Sorry, which page are we on?
2242.
Third-party malice point, is it?
Yeah.
This is their statement of case, is it, in the proceedings? Or?
This is the yes.
Yeah.
Yeah.
Right.
Starts at 2222. There's a partial translation of some of the paragraphs on 2219 and 2220. They argue that they weren't a party to the arbitration agreement, as you've seen, but the reference to that is at 2220, paragraph 81 to 89, translated. The detailed argument about that in the body of the document, Mr. Santos agreed, is from pages 2248 to 2252. At 2247, in paragraph 80, subparagraph 4, Santos agreed that that meant that the award went beyond the differences submitted to arbitration, which is essentially about the terms of reference, beyond the pedidos, which you saw is the same as the plural of the claim. Santos's evidence is at on this is at page 432 to 3. And at page 77, I asked him between lines 10 and 13. Sorry, page 433, page 77 of the transcript. Between lines 10 and 14, I asked him whether this is about the terms of reference, and he said correct. And at page 2220, paragraph 96 and 99, there were in fact two excess of jurisdiction arguments. One is that you exceed the terms of reference. The other one is that you are outside the arbitration clause. The second argument, which my learned friend, I know he's not making now, but certainly made below, is at 96 and 99 on 2220. i.e., our arbitration clause relates to our non-compete obligation, nothing else. Then there's a notice of appeal, which again sets out issues. That appears at tab, at page, the original is at page 2305. There's a translation of the first few paragraphs on page 2302 to 4. If you go to page 2302, you can see at paragraph 4, I can only just read it, but you might be able to see it better on the screen. Paragraph 4, Roman 1 to 6, I think it is all about there being no arbitration agreement. And if you go to page 2234, no, sorry, 2234, no, 2334. 2334, paragraph 85, 1 to 3, is all about them not being bound by the arbitration clause. Paragraph 85.4 is about exceeding the terms of reference. We saw in the original claim. The fair trial violation complaint is made, first of all, looking at the English translation on page 2303, at the top, 4.7 it is, all the way to 12 over the page, is all to do with the fair trial violation. And the detail complaint about that is at 2358. And that Santos agreed that this was the due process complaint. In the transcript at 434, pages 82 to 83. So you have, in terms of the pleadings, both before the judge and before the Court of Appeal, all the complaints that are being made before you, with the slight nuance on due process being raised. The trial judge's decision, which is a dense document, which I think you'll find at page 2297. As you know, he decided he didn't need to see any further evidence and decided the matter summarily. He dismissed, and this is important, because you've seen all the complaints raised, you've seen that they can be raised under the Brazilian Arbitration Act, and the next thing is you see him actually dismissing each and every one of these complaints at 2299.
Going back to 2297.
Yes, my Lord.
Under the ruling, he says he examines it under Article 330.1 of the Code of Civil Procedure.
Which is what we looked at in the Court of Appeal. Yeah. And before I get to the detail of it, I just wanted to show you that at the bottom of 2298, over the page, and what he does is he dismisses each and every complaint. And Santos agreed he did that, and his evidence about that is at page 433, transcript 79, lines 23 to 24. That's important because all the points that you saw raised in the pleadings are therefore disposed of, whatever the reasoning is. Although I try and trace it, it's not. It's clear that at page 2297, he summarized the issues in the first paragraph, but it's clear that, for example, at the bottom, first point relates to whether it was possible. You saw that quoted in the Court of Appeal. Much emphasis is put on the word possible as showing that he only conducted a review. But, I mean, that's really attaching far too much to one word. You might read it as whether the plaintiffs are bound, whether the plaintiffs are capable of being bound. Nothing surprising about the use of the word possible. You see, and that continues to the top of the next page, and he's dealing there with the existence of an arbitration agreement to which the respondents in this case are bound. And then he says second, and this is a bit more complicated because he's clearly dealing with 2.5 of the grounds in this paragraph. The first, with grounds different from what was argued, resulting thus in a nullity. So the first part of this paragraph, down to about 7 lines, with the judge applying the relevant law, halfway down that paragraph, is all dealing with the due process argument. Then he just starts in the sentence, remember, even if that pursuant to clause 1465, the contract would be construed and governed by the laws of Brazil, and the arbitration court must apply them to disputes. Also observed that the clause of the contract itself, as it was drafted, didn't limit the scope of jurisdiction over disputes of the arbitral tribunal. So that's the complaint going outside the limits of the arbitration agreement, clause 4, Article 32, clause 4. The clause was expressed in submitting to arbitration all disputes arising from or related to. That's whether it's covered by the arbitration clause itself. And then the next sentence, it's important also to remember that in relation to the requested relief, and this is the terms of reference we suggest, the arbitration panel didn't rule beyond or outside it, respecting it regardless of the grounds that adopted, this being the reason for which also in this aspect there was no vitiating overreach. So no excess of a judgment that goes beyond the claim is a judgment ultra petita, known as, which is, Santos explained that to us. And so overreach is really going beyond the claim. In that context, we say. No decision is observed as unjustified and violates. And then the third aspect is really part of what he's dealt with in the first part of the previous paragraph. And he refers specifically to Article 21.2, which is the due process article. Documentation offered unequivocally proves the broad possibility of argument, discussion and challenges. Initial complaint, a specific indication of action alleged violated the rights of defence, not seen. That's the entire part and so on. I think you've seen that in the Court of Appeal decision as well. So all those complaints are clearly decided against the funds, and the Court of Appeal decision, as you've seen, deals with the arbitration agreement. I don't think we went quite to deal with the remainder of the reasoning. I think that, just forgive me, oh yes, so page 2414, they've finished dealing with all the texts about contract, which I don't think will leave us much the wiser, but they clearly go into it themselves. And they look at texts which go beyond anything the tribunal considered. So it's not as if they're just reviewing it in that sense. At 2414, after the sentence, therefore the appellants being bound by the arbitral proceeding is appropriate. Furthermore, claim that the arbitral award was null and void based on a theory the grounds used were different from those argued by the parties doesn't stand, since it's emphasized in the judgment appealed from, they quote the judge. And then they don't really say a great deal more. They refer on page 2416 to the principle that the judge refers to, which is essentially jus nova curiat, and then they apply it. 2417. Party has a duty of stating the facts that affect the conflicts of interest. The claim is unjustified. There was a violation of due legal process, reversal proceeding based on the argument the arbitral award was based on grounds other than those were argued or raised by the parties. Without getting into the merits of the arbitral tribunal's actions was not violated, nor was the appellant's ability to demonstrate it over the course of the case. And then they refer to the judge. And that's really, and then the rest of it is an argument which isn't made, which is about the judge, there not being reasons or not being adequate reasons. Now, I think you know, and I don't need to take you to any of the detail, but this decision was then challenged in the next layer of the courts. Essentially what happens is that they don't even think they're arguable complaints, and they go up to ask for leave, they ask the Chief Justice for leave, they ask the whole court for leave, everyone says no, and when that doesn't work, they go to the Constitutional Court. And although that might not be relevant for estoppel, it's relevant to discretion. Because what they've done is, for 10 years, they've appealed the arbitration tribunal in Brazil to every level of court they possibly could, including the court that sits entirely outside the structure, which is the Constitutional Court. It's like the Bundesgerichtshof, I think. So when you're looking at, when I come to deal with discretion, I will submit that even if I don't get quite home on estoppel, I get close to it. And the fact that all these grounds were run to the Court of Appeal and then sought to be challenged in every court and delayed the whole process at great expense and over time is relevant to discretion. And there's been no case quite so extreme in which someone has asked for discretion to be exercised. I mean, sometimes you have a decision from another court that refuses enforcement, and then you say, well, that should be relevant to discretion. This is really quite different. It's quite an extreme case. But I'll make that submission tomorrow. So in terms of what was before the courts and what they decided, you can see that all the issues were raised. All the issues that are before you were raised in some way or other before the courts and rejected. And it was open to the funds to raise them. They did raise them. And although the reasoning may not be entirely intelligible to us, the courts dealt with them, gave judgments on them, and dismissed the points. So that brings me to the public policy part of the case.
So what do you say is the scope of the issue estoppel?
Well, the issue estoppel in terms of, is there an agreement?
Yeah.
We say that's covered.
Yeah.
Was the award outside the terms of reference? We say that's covered because it's dealt with. And it was raised and dealt with. Has there been a violation? Is there a breach of natural justice? I can't answer that completely. What I can say is, in looking at that, you have an issue that's decided, which is that, and we'll have to see what that actually means, that the Brazilian process wasn't violated and that the funds were treated fairly in accordance with Brazilian law. And the question for you is how far that gets you on a natural justice inquiry. And we'll look at that. But I completely accept that isn't a complete answer. But that issue was decided, and it's relevant to the natural justice question. And we say answers a large part of it. So what I was going to do is...
Is there anything you want to say about the Court of Appeal's approach to the issue estoppel?
The Cayman Court of Appeals.
No, the Cayman Court of Appeal, because some criticism was made of how they approached it and what they had regard to and so on.
I don't think they dealt with the evidence and the issues in the same way I dealt with them. These submissions were made to the Court of Appeal. The judge took 8 months to give her judgment, and I suspect forgot a lot of what was submitted to her, because she refers to none of the judgments in Brazil, none of the legislation, none of the cross-examination. She reaches her conclusion on issue estoppel on a page, double-spaced. The Court of Appeal took 7 months to give a judgment. They did it over 5 pages, and I don't think they forgot anything, but I think Sir Bernard had his own ideas about certain aspects of it. The issue estoppel point that was took up most of the time in the Court of Appeal was the point about nuvion, whether there was finality at the lower level, because they were still in the Constitutional Court at that stage.
Yeah, and that's all gone.
That's all gone, fortunately. So that went. And then there isn't a huge amount of discussion about identity of the substantive issues, because it's not really in dispute. I mean,
Well, he did. Mr. Flynn accepted that this morning. But
yes, he did.
The basis on which he says that the issues aren't the same is because of the nature of the judicial process in Brazil, which was only a review process.
Yeah.
Whereas it would be a an ordinary judicial determination in this jurisdiction or in Cayman.
And the Court of Appeal relied on Santos's cross-examination, that it wasn't just a review, that it was an ordinary proceeding. And they were right to do so in my submission, because that's really what it comes to when you analyse what he says, right from the beginning, when he says it's a matter, it's like any other ordinary action. And he can't, and he never points, no one's ever pointed, apart from the Sester article introduced in this way, no one's ever suggested that there is a limited review. There's no text, there's no case, nothing else apart from Sester. And what Carmona says, as I said, seems to be about what it should be. And we weren't able to ask him that during the trial because it wasn't put to him.
The scope of the terms of reference is a question, is it governed by Brazilian, a question of interpretation governed by Brazilian law?
Well, the way it's approached has to be approached by the Brazilian arbitrators, and what they're looking at to see whether something goes outside the terms of references, whether it walks outside the petitum as they would in another action. So they apply their own procedure to it, and when they look at claim, they're looking at the prayer. So I say, but
it's not just a matter for the arbitrators.
Well,
it would be a ground of review, a ground of interference with the arbitration award, wouldn't it, if they'd made a decision outside the scope of the reference?
Oh, yes. Oh, yes.
So I'm just trying I'm just trying to identify what you know, what that question is. If it's a question of interpretation of the terms of reference and whether they're governed by Brazilian law, whether there's a different correct analysis.
The judge of first instance and the Court of Appeals in Brazil don't seem to have received any evidence of, or any suggestion
that it was foreign.
That the issue as to the interpretation of the terms of reference was governed by any particular system of law, so they presumably just applied Brazilian law. I
mean, the point, you're absolutely right. I'm so sorry, I got carried away. I'm not supposed to try and prove any of these grounds don't exist if we did them by our own lights. The agreement, the terms of reference, and so on. The fact is, as you said, my lord, that these things are decided by the Brazilian courts without, in this case, any other evidence of any other system of law. And they had the opportunity to do that.
Mm. I understand all that. I'm just trying to identify exactly what we should take it that the Brazilian court has decided, so that what is potentially an issue at the stop, or what is the issue?
The issue is whether you've walked outside, you've exceeded your jurisdiction under the terms of reference.
Yes. And that is a question of construction, I would think, of the terms of reference, which is a document governed by the law of the agreement, which is Brazilian law. Is that right?
Yeah, it must be jet lag. You put it better than I did, and that's the way I put it.
I mean, clause 14.7, I'm looking at the Court of Appeal, paragraph 22. The arbitration panel shall decide the matter submitted to it only in accordance with provisions of law and must base their decision on the laws of Brazil.
Yeah.
It looks like that.
And we also know from the pleadings that they raised this point, and we also know from what Santos agreed, the judge decided that he rejected.
Yeah.
The due process argument is, I think, can only really be made, as I think my Lord Legate put to my learned friend under 5.1b, you're not likely to have another complaint on public policy. And that point's made in Chukarova, and you may have had that in mind at 3488, paragraph 33. So you're not dealing with public policy at all, which is a reason why an issue estoppel that is relevant to a question of whether someone had a fair hearing can be looked at. Might be harder to do it when the question is public policy in the abstract. And to be fair, in my learned friend's case, he doesn't really make much of the other ground, although I wasn't sure when he was on his feet. The second point I wanted to make about just legal principle is by reference to Adams and Cape. I ask you to turn up page 4258. Remember, that was about enforcing a Texas judgment. And one of the complaints was that there'd been a breach of natural justice.
But it's not a convention case.
Sorry,
It's not a convention case.
no, it's not, but it's a natural justice point. And it's an international enforcement case, but it's not a convention case. That's absolutely true. But I respectfully suggest you get some assistance from the way in which natural justice was discussed. At 4258, they refer to Mr. Justice Scott's reference to Pemberton, and you see it just above letter F. What we're looking for is something that offends against English views of substantial justice.
This is sort of public policy point, isn't it?
Well, it's natural justice. If you look, the heading is on page 4257.
This is enforcement of foreign judgments, is it? And,
yes.
Yep.
And it's a legitimate complaint about a foreign judgment that it doesn't comply with the rules, that the court didn't comply with the rules of natural justice. And so under that heading, they refer to Mr. Justice Scott's judgment. He refers to Pemberton. Thus, in the opinion of Mr. Justice Scott, if the natural justice objection were to succeed, the proceedings in the foreign court must defend against English views of substantial justice. So if it's a question of English law and substantial justice, if it's our concept of substantial justice that matters, it has to be, it's put in that way, it's put quite highly. It has to offend, and it has to be against our notions of substantial justice. And that passage is then, you see on page 4259, what Mr. Justice Scott says, and he's dealing with Texans in 1980, so he probably wanted to make this point, that you can't divorce that notion from the legitimate expectations of both the plaintiff and the defendant in the context of the procedural rules applicable to the case. So we say that has obvious application here. And that's proved.
Well, why? Because the procedural rules were the ICC rules. There weren't any Brazilian procedural rules. It was only the Brazilian substantive law that was applied by the arbitrators.
There's no complaint that the tribunal didn't comply with the ICC rules. The complaint is that they, in their fact-finding, the stuff that isn't covered by the ICC rules, they adopted a process which was unfair. And what they adopted is a process which applies in half the world. There's nobody who says you can't do that. The ICC rules don't say you can't do that. And you've got to have some form of, process for judicial determination. And we do that differently. We have the adversarial tradition in a much more stark form than other countries do. As you'll see in a moment, they have they have the principe du contradictoire, if I pronounce that properly, or contraddittorio, as we were told, which is the adversary principle, which has its limits, and I'll come to that in a moment. But there's nothing that suggests that the ICC rules don't accommodate that. It wasn't put like that before. I mean,
No. I was just just suggesting that it's not the Brazilian procedure that applies in the arbitration.
No, I mean it's not insofar as it's taken care of by the ICC. That's absolutely correct. But insofar as the tribunal has to come to some decision.
It's up to them what procedure they adopt, subject to basic constraints of fairness, presumably.
As my lord put to my own friend.
Yeah.
Yeah. And the point about substantial justice and the sort of fairly high threshold is also made in the commentary on the convention, the guide, which is at 3958. In paragraph 33, you can see, in practice, courts have refused recognition enforcement where the process has been particularly egregious, radically strayed from standards of due process. And if that's internationally accepted, and it seems to be accepted in England as being a test for enforcement, that you have to have substantial injustice, we say that ought to be the way in which due process complaint is looked at here. Can I just deal with min metals quickly? That's at that passage my learned friend took you to, because it arises in this context. It's at page...
So you say it's the English principles of substantial justice or natural justice that apply.
Which seems to be reflected by international principles, because the guide, the Secretariat's Guide to the Convention makes the same point in that passage I tried to show your Lordship. Has to be particularly egregious.
They start talking about by which standards you judge that, and that's suggesting perhaps it's independent.
Yeah, but it has to be. It's true. It doesn't tell you by what standard you do that, but the reference to egregious and sort of more obvious cases is, we suggest, consistent with requiring something more than just a mere breach of natural justice. I mean, something that might get you home on a judicial review would not be enough. Particularly egregious, radically strayed from standards of due process.
Well, one example they give is the party denied the right to comment on or respond to evidence and arguments from the opposing party.
Yeah, well, that doesn't happen in Brazil. I mean, there is a right to argue about what the other side say. There's a right to argue about their evidence. There's a right to present evidence. It's not a kangaroo system.
No.
Can I turn to min metals? I don't know if I can take that any further. I mean, as far as one can see, I don't know if Mr. Bourne's work will take us much further, but there are 2 points to make really with the standard. One is that if it's a Cayman standard, an English standard that you apply, and it seems to be said in some circles that that's what happens, that seems to be Chukarova, then at least you have Adams and Cape that shows when you're looking at enforcement of other judgments, and there's no public policy consideration that we enforce those judgments readily. You still apply a substantial injustice test. At least you should do that in an arbitration, because enforcement is supposed to issue more readily. And if you do it internationally, we wait to see what Mr. Bourne says, but at least as far as that commentary is concerned, it looks like you also need something a bit more than just the average breach of natural justice. Min metals, I think your Lordships have made most of the points I can make about that. It's the passages at 3692 to 3, I think it was, 3693, between letters C and E. And it's said from this that the enforcement, the court whose judgment's being enforced can't trump, and I think it's taken rather further in the case, I'll show you that. You can't trump our own rules of natural justice. I think that's the way it was put. This is we say a common lawyer's view of how a civilian system works. What he's looking at is not simply a civilian court referring to its own law, but an inquisitorial court gathering its own evidence, which is rather odd. I mean, that's not what happens in Brazil. The judge doesn't go out and look for evidence. And actually, when you read the whole of the passage down to 3694, you can see it's obiter, because what happens is that the rules were changed, and then at 3694, letter F, he says, because they've changed and they took they made no effort to adduce further evidence. He says at letter F, I've no doubt whatever that FERCA had not been unable to present its case. On the contrary, it had been given every opportunity to do so. What had gone wrong was that its counsel had simply failed to take that opportunity. So by the end of the hearing, what he's saying is, having made the observation he made that was read to you, in fact, it's all obiter. He doesn't really have to make that point. He doesn't take account of Adams and Cape. He doesn't refer to any of the commentary on arbitrations. He just seems to, as I think your Lordship said, where it has come from. And there's no answer to that.
I don't have any problem with the idea that in many systems, indeed we tend to do it here more and more, that the court goes away and does its own research on the law and comes up with something that the parties haven't thought of. But I do find it surprising that in any system, it's acceptable for the court then, or the tribunal then, to decide the case on a whole legal basis that hasn't been put to the parties, and that just feels unfair.
Yes, I can see that, but that's not quite what happened.
Well, you can show us that, but I would also be helped overnight, perhaps, if we've got this great chunk from the book Jura Novit Curia, which goes into all the different systems. I haven't read it all, and I'd hope if there may be some page references that could save the time, but on page 3356 of the bundle, when there's a summary of what the whole book is meant to say, and in the middle of that page, after referring to the reports from the 15 different jurisdictions, there are 5 basic principles which they're said to converge on. And principle 3 is the tribunal must give both parties the possibility to be heard and comment on the basis for the tribunal's decision. So if that's not accepted to be a general universal principle, then I'd be grateful for the references it's not. Or maybe you accept that principle and say it was complied with, but if it's not, if you say that isn't generally accepted and half the world disagrees with it, I need to be persuaded of that.
I would myself need persuasion of that too, but I'm not going to suggest that to you. The way it's dealt with, though, is not quite like this. Not on the same way that you would do it if you did your own research. What normally happens...
Sorry, can I speak? You accept the proposition then at Roman 3?
Well, what I accept is that in almost every civilian jurisdiction that has Jura Novit Curia, you can't surprise the party with a basis of claim that hasn't been properly made clear to them. So it's
how does that work here?
Well, I'll come to that.
You're going to come to that.
Come to it.
In terms of the proposition at the moment.
I mean, you would accept proposition 3.
I accept that you can't surprise people with something. You have to work in the confines of a system where the judge will take all the facts, where the parties will argue the facts, they can characterize the facts, and if you allege fraud, it's going to be pretty obvious that you're going to have some sort of hook to hang it on, and you'll see that fraud was all over the allegations. What you can't do is come up with a characterization that no one's come up with before that is completely different and surprise them. And that's obviously fact-sensitive, what amounts to surprise. And you saw in their complaint that they alleged surprise. And Mr. Gomes Santos says you can't do that. And, we can't say that principle didn't apply in Brazil, because by the time his evidence was that although there was a new provision introduced into the Civil Procedure Code in 2016, his evidence was that it had applied all along, That was actually a qualification to the jus novit curia and an addendum to the adversary principle that you can't just surprise someone. But what amounts to surprise is fact sensitive.
So just to be clear, you're accepting this in the context of international arbitration or more generally?
I'm accepting this as a matter of Brazilian law. I'm not, I mean, in terms of arbitration, I'd accept the same thing, that in essence, you can't surprise someone. There's a principle of surprise. I'm going to show you a Swiss case, not because I want you to follow it, but it shows you what I'm talking about.
But in a sense, I think what you're really saying is that whatever system of law is the right system to apply, this principle that you can't take somebody by surprise would apply. Yeah, and you'll see it time and time again in this book. You'll see it time and time again in some of the cases, and you'll see it. We were shown even a Brazilian case where that was said, and Mr. Gomes Santos evidences to that effect, and so we know that's the law in Brazil, and we know the courts decided that question in Brazil. Well, it was the problem in min metals first time round, as it were. Well, they get rid of the min metals problem by having a rule that you can't go outside the pleaded facts. So the judge can't go off and make an investigation, because that's a strict rule in Brazil. You can't go outside the facts or the claim. So, but while we were at that concluding chapter, you might like to look at page 3338, so I don't have to go back there. Thank you. I think this is the last chapter. 3338. Thank you.
No, this is in international law. I think that's the previous. It's a chapter. It's a topic on its own, international law, as opposed to the law of the various countries they've gone through.
But you'll see here a point that comes up in all the civilian systems about not going outside the petita, ne ultra petita, and that was a complaint that was made in this case. I'll give you some reference to it. The main point of showing, of producing the book, and I showed Mr. Santos the book. I said you get many different courts and many different countries applying the adversary principle. They all do it in slightly different ways, but it all comes down to the fact that ultimately, within confines of these restrictions, the court has the ability to make its own characterization of law, and he agreed with that. The precise detail of the book doesn't matter. It was really to show the court that half the world does it. It's a very respectable juridical system. There are obviously variations on it. A party hasn't been denied justice, and you've seen that in min metals. It's also in the commentary. A party isn't denied justice if it hasn't taken the opportunity to present its case. So the opportunity to present your case is obviously dictated by the rules and the procedures of the system you're in. The Brazilian system does give the N4C a clear opportunity to present a case. They're required to come up with their own legal analysis to fit the facts if they want to. They don't have to. And here, when you look at it in a moment, you'll see that the N4C was accused of fraud. And if you're accused of fraud, and you're accused quite widely of fraud, as you'll see, it really is odd that you don't realize that the section that might be invoked is one which makes you liable.
Well, you might think that if the only claim in the terms of reference is a claim in contract, you don't have to get out the books of tort.
Well, the claim, that's the whole point. In that system, your claims are just part of characterization that doesn't bind anybody. So you set out the facts. This is what's so different to here. You don't plead endless legal points. You don't plead conspiracy. You plead them as facts. So if you think from those facts you have a claim in contract, you can plead that. That's a characterization breach of contract. But the court's not bound to adopt that. And if you set out a fraud and then you say, I want contractual damages, the court doesn't have to accept that you've got contractual case. And you'll see what the court did, what the tribunal did, but it wasn't as stark as Miller and Friends said. And it only works if you express a claim in the way a common lawyer does, because we would never think of a claim as being complete without a legal cause of action. But all they do in those countries is all they have to do is plead the facts, set out all the facts. These parties, of course, were advised by big law firms, and they were well capable of understanding what might happen in a system like Brazil, the Euro-Novit-Cura system. And you have to ask yourself why, there might be legitimate tactical reasons why a party doesn't deal with these allegations head on in their characterization, their own characterization. You might not want to give the judge all the tools to get you. If the other side don't seem to be alive to something, you might not want to give him the legal analysis to get him home. And what you'll see is that the funds didn't actually put out much legal analysis at all. Or the one they did was addressing something different. What they never did is head on say, we couldn't be liable because of causation or something. They actually do argue about causation. They argue about reliance. They argue about whether they're responsible for the representation. They argue whether the representation is really fraudulent. So all those things are actually in the documents. I'll show you that. In Milan and Friends' case at page 2796, letter F, it's suggested that you cannot look, by reference to min metals, you cannot look to the supervisory jurisdiction. I just wanted to point out that there is that's not actually what min metal says at all. Remember, in min metal, the judge was dealing with the PRC court, which had given a judgment. It wasn't dealing with a supervisory court that had held that the PRC court had given a good judgment. There was no supervisory court in min metal. It's dealing with the examination of the court whose judgment is being enforced. And it's examining whether that tribunal gave you fair opportunity. It doesn't have anything to say about a supervisory court that looks at that, like the Brazilian courts did. So min metal doesn't mean that the decision of the São Paulo courts on what occurred before the tribunal is incapable of giving rise to an estoppel. There are three English cases that are dealt with in the case. I'm just going to deal with, well, Malacorp and I think Canoria were both dealt with orally. We address Malacorp and these other cases in our own case at 2784-5, paragraph 58. And what I would say about them, you'll see this from Malacorp, I think. None of the cases was it said by the plaintiff that they had complied, that the tribunal had complied with local procedure. So in Malacorp, it wasn't, for example, said that the arbitral tribunal had complied with Egyptian procedure or the ICC rules. That wasn't an issue. So none of the cases examine a procedure different to common law. They're all concerned with, they all assume, and I mean, because it's not argued, there's no one who goes along and says, oh, but they complied with all the rules of civil procedure in Egypt. In fact, in Malakoff, the Egyptian Court of Appeal, I think, had set aside the award. Mm. And we don't know on what grounds, because I can't see it from Mr. Justice Walker's judgment. I think your lordship made the ex parte order.
I can't remember that far back.
That's in the judgment. I saw that.
I have no recollection of ever making that order.
I think
he says very defensively.
I've attributed that correctly. Yes, the point about Malakoff, if we just maybe look at it, it's at 3669.
It was a very ambitious application in the sense that they had lost in Egypt and they'd lost in France. I think they'd lost in the Cour d'appel de Paris as well.
Cour de cassation.
Well, it was Cour de cassation, was it?
Yeah.
Three page number again?
It's 3669.
Thank you.
3669.
Yeah.
And I've looked through this, and you can't tell why why the arbitration award was set aside by the Egyptian court. It doesn't say. Well, I couldn't find it. But there isn't any argument. I mean, you get to the relevant principles at 3678, and they refer to Tukarova. But nowhere is it suggested that, oh, well, when you're looking at Tukarova, please take into account that every facet of Egyptian procedure was complied with.
Egyptian procedure doesn't matter again. I mean,
it doesn't.
You can't be too parochial in international arbitration, because at least one of the parties is not, that's the whole point about it, it's not going to be Egyptian, and so they're not going to be governed by Egyptian rules of procedure.
We're on the same page. It's not raised, and it's not argued, and it's therefore not the same as this case, because here it is argued, because here it covers something that isn't covered by the ICC rules, we say. And we say, in any event, it's here
well,
Brazilian...
Is the point you're making there, by reference to Article 14.7 of the arbitration agreement, that the tribunal was to apply the laws of Brazil?
And whatever, as my Lord Legate said, that when they get to a point where the ICC rules don't help them, they decide what procedure to apply. They're all Brazilian arbitrators. So they're going to apply Brazilian law, probably, Brazilian principles of procedure. The INC...
I think one of them was actually Spanish, wasn't he?
Oh, I'm okay.
I think one of the arbitrators was a Spanish law professor. You may be right, the other two were Brazilian.
I'd forgotten that. I'm sorry, I misled you about that, but at least they, I don't know whether Spain has the same principle. I imagine it does. Well, we can have a look at the book in a moment, but...
But it doesn't depend. I mean, it doesn't depend on where the arbitrators come from. One has to adopt a fairly internationalist approach, I would have thought, in this. However, look at it.
They can choose to. They can choose to.
Yeah, and they may have a very broad. I mean, you may say, well, it's within their discretion, if you like, as to what procedure they adopt. Obviously, they've got. One can take account of the variation of national procedures that there may be.
And the parties didn't, I mean, certainly the MP parties didn't say, well, you must apply Anglo-Saxon procedure, some national procedure, whatever it is. They didn't say anything like that. So the arbitrators apply the procedure of the country.
They do what they think is fair.
Yeah. But they're applying Brazilian. There's nothing wrong with them in the context of a vacuum applying Brazilian procedure. So
there's nothing to say they did.
I'm sorry, my Lord.
There's nothing to say that they did. If they were wondering what to do, shall we give them a chance to make a submission about this? I don't suppose they got out a book of Brazilian law. They probably just, if they thought about it at all, they got together and said, well, What do we need to do here? What's the fair thing to do?
Well, the courts seem to think that they've applied that because they came up with their own characterization. They said that's perfectly all right in our system, and there wasn't any surprise. I'll come to the surprise. But there's no reason why, on that basis, the court can't find that the tribunal acted fairly. It wasn't argued, incidentally, in the courts, as far as I can see. It's not argued in front of the Court of Appeal that fairness meant that they had to apply some different system. They just said you can't have surprises. You know, the adversary system, at least in an international arbitration, they argue about international arbitration, requires you to have, and this was, Gom Santos's point wasn't that INC doesn't apply. His argument was it doesn't apply if the judge can always surprise you with these things. They have to canvass something that is a surprise. And he might have put it even more strongly than that, but the point is that it's not that the Brazilian system shouldn't have applied. It's whether or not it should apply with surprises. And the evidence, in fact, is that the Brazilian domestic system doesn't permit that. That was Santos's evidence. This is why it was introduced in the Civil Procedure Code, Article 501, which he produced. If that's correct, then nobody would have said that Brazilian procedure couldn't be used, because it's no different to what's used internationally. It's no different to the principle, really, that your lordship showed me in the book. It's just, it's expressed by reference to surprises. But my point, really, in relation to these three cases, and your lordship's made the point rather differently, is that the local procedural law is never raised. It's never a question. It is a question here. And what I was really trying to do is show you that Malicorp is not relevant here, because it doesn't help you answer the question, because they're looking simply at a common law natural justice problem. Doesn't look like there's any other system being looked at all, and why should it be? The same is true of Canoria. So it might be that I'm going to come to what INC actually entails, and the sub-rules. Maybe better if I do that first thing in the morning. I've got...
You're saying it's the local procedural law because these matters are not covered by the ICC rules, and the supervisory courts are Brazilian courts and will apply their law. Is that right?
Yes, and they weren't. There wasn't any reason for them to apply a foreign law or an international law.
This is I'm a bit confused as to whether that's your submission as to what the Brazilian courts were doing. I understand it is. Whether it's also your submission to what the Cayman court ought to be doing, applying what's transposed as Article 5(1)(b) into Cayman Islands law, where I thought earlier you were taking us to Adams and Cape, and it's a question of English conception of substantial injustice.
Yes, but it's not a substantial injustice if you have regard to the system, the other part of Adams and Cape, Mr. Justice Scott. You have regard to the system in which the problem arises, which dictates the expectations of the parties.
Right.
And so you're looking at a Brazilian issue in my submission, for just cutting it short.
So you say, although it's an international arbitration, for the arbitration, and although it's not Brazilian procedure that applies in the arbitration, it's still Brazilian concepts of procedural fairness that are relevant.
And so decided the Brazilian courts.
And why? Why is that? Why are those concepts relevant? Because two of the arbitrators are Brazilians, or one of the parties is, or?
Well, I don't know how I would have decided the question if I was the supervising court, but they were...
No, but we're not concerned for this purpose what the supervising court thought. We're concerned with what we think.
Well,
If it turns out to be the same as the supervising court, you might have an issue of estoppel. I don't know, but
But the Brazilian court, sorry, finds that that's what I lost. So the Brazilian court decides that the parties were treated fairly in accordance with the principles, INC principles, not peculiar Brazilian principles. It decides that they were treated fairly, and now we know that that's where they were, and there's nothing wrong with those principles. Why would the Cayman court decide, well, we are going to apply an Anglo-Saxon notion of what parties have to be told, when they're actually sitting in Brazil in arbitration, ICC arbitration in Brazil?
so are you saying then that where the seat of the arbitration determines the procedural law that's applied? I thought you weren't saying that, but maybe you are.
Well, no, the argument below was we had a big controversy in front of the judge, which is why I'm slightly taken aback by it. We had a big controversy before the judge whether the tribunal was governed by the law of the seat of the arbitration and to what extent and why. That was dropped in the Court of Appeal. We didn't have that debate. It was raised by my learned friend in argument, and I need to go back and think about why we argued it that way and what was said below. But I'm not saying it's because, I don't think I'm saying it's just because it's the seat. No. I'm saying also because the arbitrators had a discretion on what to do, and what they clearly did was apply, they came up with their own characterization. They're allowed to do that only in that system. They're not allowed to do it in the Anglo-Saxon system. And
we've got this very odd clause in clause 14.7. The arbitration panel shall decide the matters submitted to it only in accordance with provisions of law and must base their decision on the laws of Brazil. So what does one make of that?
I have to think about that overnight.
I mean, does that encompass Brazilian concepts of procedural fairness, as my lord put to you a moment ago, or not? I mean, that might be something you'd like to think about overnight.
I'll think about it overnight, but I mean, there wasn't a debate in the Court of Appeal that INC applied. My learned friend says he doesn't mind INC. He just whines about the surprise element of it. So nobody actually suggested that it was some sort of other procedure that applied. Mm.
Well, we've had a lot of questions, actually.
Yeah.
No, I'm sorry. I'm sorry I wasn't...
Patience.
Yes.
So reflect on those tonight, I'm sure, as you will. And tomorrow morning you have another hour and a half, I think.
I might not need it all, but thank you.
As much of it as you may feel you need to address any outstanding issues and indeed any of the questions you've been asked this afternoon.
Thank you, Will.